This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
So this is your chance to ask Todd Lutsky your estate planning questions live on air. Todd's with us here, and we got the phone lines open at 888-205-2263. Remember, we don't always get through everyone, so if you want to make sure we get to your question, call early, call often. Well, really, call once, like Tucker will pick up. But that number is 888-205-2263 in order to speak with Todd Lutsky about any estate planning questions that you have right now. Again, 888-205-2263. Get calling so we can make sure that we get to your questions. Mr. Lutsky, how are you doing today?
I am doing great. How about yourself?
Pretty good.
Yeah? What's going on?
Have you ever thought about buying a telescope?
Not generally, no.
You should look into it.
That's right.
So, Todd, I want to talk to you a little bit about estate taxes and trust work.
Okay.
How does creating an estate plan using trusts potentially work to minimize estate taxes?
And you know what? It's fair, especially when we talk about, federal and state. So remember, state, I will be mentioning more about Massachusetts. Please check your own state for those laws. But the federal, and it's strange because when you talk about a federal estate tax, a lot of people don't think they need it, right? And it's true. I mean, the exemption is $13.9 million come January 1. Let's just call it $14 million for easy numbers, right? Well, if you think you have a large estate, like, oh my gosh, I'm worth $20 million, and again, that's a large estate, you might be thinking, wow, I've got all kinds of estate tax planning I have to do. I bet you it's real sophisticated, and I got to get into all these special techniques, and guess what? No. Right now, I would say that's certainly not the case. We've got a new election, or an election that took place. We've got a new president coming in, and I think the exemptions could stay high for a while. So when I say that, if you are a married couple and you are worth $20 million and you're thinking, wow, I got to do all kind of sophisticated planning, basic, revocable trusts, or what I like to call estate planning 101, which is really the foundation of estate planning, pretty much can eliminate your estate tax. And it's amazing because if you don't do anything and you're a married couple and you just, I leave everything to my spouse and I'm worth $20 million, well, the surviving spouse will be worth $20 million, and you could have potentially wasted your $14 million exemption. Say you didn't do planning and you didn't elect portability, and it's very possible when you don't plan, none of that happens. And so the surviving spouse is worth $20 million when they die with a $14 million exemption. Yeah, you have $6 million subject to tax. You figure federal and state, 40 and 10, you're looking at 50% or $3 million that you're giving away. However, to your point, Chuck, a simple revocable trust, one for each, put $10 million in each trust, and when one dies, you really have the ability through the marital share and the remainder share built into this trust to shelter that $10 million. So it'll be subject to or included in the estate of the first spouse to die, but not the second spouse to die. So $10 million minus $14 million, no tax. Survivor dies, and the surviving spouse's estate's now only $10 million because we're not going to include what was in the deceased spouse's estate, or the deceased spouse's trust, I should say, leaving her with $10 million. We have an exemption of $14 million, no tax.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you've got a question for Todd, the number is 888-205-2263. That is the number to call to ask Todd your question live on air. We still have a little bit of room on the phone lines. So 888-205-2263. That is the number to call. We are going to take a quick break right now, but when we come back, it's going to be right to your questions with Todd. Again, still a little bit of room on the phone lines. 888-205-2263. Quick break, then your questions.
Ask Todd with Todd Lutsky every Wednesday at 10:30. Only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right, Todd, we've got some calls for you, so here we go. Let's kick things off with Daniel from Worcester. Daniel, you are on with Todd Lutsky.
Hey, how are we doing today?
Good.
Good. So my question is, if I wanted to leave everything to one of my children or my son, how are things not able to get held up in court under, like, probate? Say any debts, past taxes, and any bills, things like that. If I just wanted to leave him all of my assets, is there a way around that?
How many children do you have?
Just the one.
Oh, okay, because you made it sound like I wanted to leave it all to just one child, and that made it sound like you were going to be disinheriting other children. Maybe that's just how I heard it. But and that, of course, makes it a little more complicated. You certainly could do that, but then you always got to worry about making sure there's no fighting after you're gone. So, yeah, this is a more simple, I would say. Are you married?
No.
No. So, how old are you at this point?
I am 45.
Okay.
44? 45? Yeah. I'll be 45.
So, no more tough questions. So, the answer is pretty simple, I think, for you. I don't know the size of your estate. Are you under, like, the Massachusetts $2 million level, or are you over that?
Yeah. Nope, I'm under.
Okay. So, good news on that front is we're not really worried about taxes. I want to keep you in control, so you would be the trustee. I would want you to be the donor. It would be simply a revocable trust and put your assets into it. So during life, your life will not change at all. You get to do everything you do today. You will not need to file an income tax return special for this trust. You will just continue to file your personal 1040 like you always do. And life will go on relatively unaffected, the old set it and forget it idea. And then, though, what you're looking to accomplish will happen when you die. Everything in the trust avoids probate, and it passes. So if it doesn't go to probate, creditors can only attach assets in your probate estate. This is outside of your probate estate, so it'll pass directly to your child, or you could control it depending on how you want to leave it to that child. Do you want to put it in, have them get it at certain ages, like 25, 30, 35? Do you want to have it controlled and protected from future creditors? All of those things you will discuss with your estate planning attorney to design how your child gets it, but that will accomplish your objectives. Folks, speaking of accomplishing objectives, sometimes avoiding taxes is one of those objectives. There's a new article this month, A Tale of Two Objectives: reduce taxes and protect assets from the nursing home. So it's really for everybody. It explains probate, it explains the portability rules, and it explains with an example how, with a revocable trust, a marital share and a remainder share can shelter assets for estate taxes, like I was explaining earlier when Chuck asked the question. However, it also deals with the Massachusetts estate tax, the new Massachusetts estate tax 1 year later, of course. And then for folks who are more concerned about nursing home planning and taxes, well, then we have a section in there regarding irrevocable trusts and how those are designed to provide both of those benefits at the same time. So, folks, there's a little bit of everything in here, something for everyone. 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, let's queue up another one for you here. We've got Chris in Milton. Chris, what's your question for Todd?
Hi, Todd. Thank you for answering these questions. It's nice of you to do that. My question is on the Massachusetts estate tax, the quote-unquote new estate tax.
Yes.
Say if somebody has a gross estate of $2,050,000, okay?
Okay.
But they have allowable deductions of, say, $75,000.
Okay.
So that lowers the net estate to $1,975,000.
Got it.
Does somebody even need to file the Massachusetts estate tax return? I mean, is it based on the gross estate, or the estate after these allowable expenses?
Great question. It is based on the gross estate. So you would need to file even though you're not going to pay any tax. It's going to pull you under the estate tax exemption. But because the gross estate is over the filing threshold, which is in essence what this $2 million exemption is in Massachusetts, it's more of a threshold, you would still need to file the estate tax. But because you're at $1,975,000, it would result in zero estate tax due. Versus if your gross estate was $1,999,000, then technically you don't need to file. So hopefully that was helpful.
Todd, we got another one for you here. Let's go to Phil in Worcester. Phil, what's your question for Todd?
Hey, Todd. I thank you for what you're doing. I just turned 55.
Mm-hmm.
I have really no family, no kids, no wife.
Mm-hmm.
I have roughly a small, meager 401k that I've rolled over to a Roth,
Mm-hmm.
and I just don't know if I should be looking at a trust at this point.
How much are you worth in total? Under $1 million, under $2 million?
Well under.
Okay, so probably not. I mean, again, I want you to do only what you need to do. Not to sound like a Liberty Mutual commercial, but I got to tell you that for someone in your situation, simply name a designated beneficiary on your Roth, put a designated beneficiary on whatever bank accounts you might have, or maybe other investment accounts that you might have, and then they will go directly to those people listed as beneficiaries, and they can take it, and it will avoid probate. No need to get bogged down in trusts and wills for you. So, but hopefully that's helpful.
Todd, let's go do one more here. We'll see if we can go 4 for 4 on this. Let's go to Bill in Osterville. Bill, you're on with Todd Lutsky.
Hi, Todd.
Hey, Bill.
The question is, if there's an irrevocable trust,
Yep.
Can you sell the house? In other words, she has two houses, and she wants to sell one so that she can be taken care of.
Is this a single person?
She's a widow.
Widow, yeah, so single at the time, right. So I don't know, I didn't draft the trust, but I'm going to tell you how our irrevocable trusts work, and I'm assuming this was a Medicaid irrevocable type trust, because remember, there's many kinds of irrevocable trusts. So let's assume that it's a Medicaid irrevocable trust, and she wants to sell it. Our trust absolutely allow for the sale. Super simple. She would direct the trustee to put it on the market. It would sell. Money would go, or the house would go out, the money would come in. Our trusts are also designed as grantor trusts. So she would still be entitled to her capital gains tax exclusion as a single person if this is her primary residence of $250,000. The first $250,000 of gain would not be taxed for her. And then the trust can actually use that money either for investments for her to live off of, or you could maybe downsize. Maybe she wants to now buy a condo and just not have to worry about maintenance and upkeep. And so money would go out and a new house would come in, or new condo would come in. And arguably that transaction would not impact the 5-year waiting period if she did that for Medicaid eligibility. So you just need to read the terms of the trust. That will tell you whether she can do it or not. I hope it's drafted properly. I know in our trusts that can absolutely be done.
Todd, one other question just that I have for you, just kind of getting back to what we discussed in the prior segment. Let's say that someone had done estate planning previously, and maybe now they're concerned about estate taxes. Their estate may have grown since they did it.
Yes.
How would someone know whether or not they need to update previous estate plans?
I guess the only way to really know that is to keep an eye on what your assets are, right? We try to educate you as to what those exemption amounts are. And at those exemption amounts, if you know your estate has grown, call your accountant, call your estate planning attorney, check in, right? I always tell people, check in with your estate planning attorney and try to figure out where you are. And so if the estate tax has gone up high enough that now it's causing you to be an estate tax problem, he'll tell you or she'll tell you, and you will be able to adjust your plan to maybe do more sophisticated planning as the case may be.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated.